Grace Project is a non-profit organisation aiming to creatively combat gender-based violence and femicide in South Africa. In August of 2021, one of our followers sent us a message, a rape survivor, the second applicant in this case, highlighting the issue of intent in the Sexual Offences Act. This issue was further amplified in the Coko judgment on appeal. In October of 2021, we sent a letter to the President highlighting this issue. At the time, the Sexual Offences Amendment Bill was sitting on his desk to be assented, signed into law. So we requested that this bill go back to Parliament and the definition of rape and consent be revised. We were subsequently ignored. We did not receive a response, and that is why we decided to launch this legal challenge.
This is a constitutional challenge to the Sexual Offences Amendment Act and its problematic definition of consent. Consent is an incredibly important factor when determining whether rape or sexual violence has been committed. But the difficulty with the definition of consent in our law is that it requires a subjective standard, what the perpetrator thinks or feels, rather than an objective test, what a reasonable member of our community may view in that circumstance and whether or not consent was actually freely and voluntarily given. This poses difficulties when we are trying to prosecute rape and sexual violence matters, and courts often focus on the conduct of the victim and survivor rather than on that of the accused. And if the accused subjectively thought or believed or felt that there was consent when reasonably there was not, it means that the accused could rely on this defense, this subjective belief defense, in order to avoid being found guilty of a charge of rape or sexual violence.
The applicants argue that as the Act currently stands, it is unconstitutional and outdated. It violates several rights of victims and survivors, including their rights to equality, dignity, privacy, and freedom and security of the person. Further, it disrespects women's sexual autonomy. As a result, the applicants seek a declaration of constitutional invalidity and propose an interim reading into the Act to allow Parliament to remedy the legislative defects.
And this, we hope, will have the ultimate effect of ensuring that victims and survivors can access justice.
I just want to thank everyone involved in this, our legal team, most importantly the second applicant who bravely came forward and actually highlighted this issue. And if it wasn't for the second applicant, this legal challenge may never have seen the light of day.